December 5th, 2024, 9 a.m. Bond continue. Thank you, sir. Court calls case People versus Dwayne Schweitzer.
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Feitzer. Please state your name.
Dwayne Feature. Pizza.
Your Honor, thank you. And we are asking for a preliminary examination date, Your Honor, and I don't know if the court could accommodate the 10th. Please.
That was his nice way of trying to.
Yes. I threw.
He was like, I'm not going to pick my date, but could the court accommodate that?
You're on my
here
tricks.
every Tuesday. What do you mean?
You're on my tricks. And yes, sir.
People have any objections to that?
No, I thought he was very polite.
Thank you.
Really?
I agree.
It's like Simon and Hughes and like Garen and Poussin. All right. Preliminary examination in person, December 10th, 2024, 9 a.m. That is before Judge Burke. Bond will continue.
Thank you. Thank you. Oh, Your Honor, I'm so sorry. Now I'm in trouble. I told Ms. Blanche I did have a travel request. I'm sorry. It's quick. My client would like to go to a pre-planned trip to Chicago, leaving tomorrow, coming back Monday.
So the 22nd, I'm looking at the wrong one. No, 23rd. Oh, leaving the 22nd, coming back on the 25th.
Yes, Your Honor.
Friend of me traveled to Chicago, 22nd through the 25th inclusive.
Thank you very much. Appreciate it.
That's called the case, People versus Ricky Hilton. All right.
Rick Hilton here, sir. I'm here on the video court.
Good afternoon, Your Honor. House and Bed. You called Mr. Hilton, right?
Yes, yeah, they did.
Yeah. Good afternoon,
Yes,
Your
I
Honor.
did.
House and Bed. P78448 on behalf of Mr. Hilton. I apologize.
Not a problem. All right, what are we doing?
Judge, I know today's we adjourned the PCC. I did get paper discovery. I've been in contact through email with regards to discovery. I wanted to see if there's any audio or digital discovery. At this time, I think we should set up for an exam. And in the meantime, if you could set it out 2 or 3 weeks out for an exam, in the meantime, I can see if there's an offer.
Well, we don't do it that way here.
Okay.
I try to make sure that discovery is all complete, and then if discovery is complete, we set the exam.
Okay. Then, Judge, can you give us a couple of weeks to see if the discovery is...
That's fine. I'll adjourn probable cause conference to December 5th, 2024, 9 a.m.
And would that be...
Or as your invite, as your at 9 a.m. or as your invite indicates.
Thank you, Your Honor.
All right, thank you. Bond will continue. Court does call the case, People versus Myron Moyer.
Good afternoon, Judge.
Spencer Clayton appearing on behalf of the defendant who appears to be a judge.
All right, sir, can you please state your name?
Myron Moy Jr.
How you doing?
Your Honor, today's date and time set for PCC in this matter. The people did extend an offer where my client would be pleading to attempt possession of a firearm in a motor vehicle with mandatory forfeiture of that firearm, no delayed sentence on that. He does wish to take advantage of that. Enter the plea today, Judge.
We tried to enter the plea last time. The plea form should be in the file. Unless we get through it.
Okay.
We have
Let's see. Okay, I see.
get through it.
All right, the The plea form that I have indicates that the defendant would be pleading to an added count two of attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. Upon his successful guilty plea to that charge, count one would be dismissed. There is further the agreement of no delayed or deferred. Is that right?
That's the correct statement.
All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record.
Myron Moy Jr.
All right, you can put your hand down. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,250 fine plus court costs and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, understood.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I do.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand that you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
You're doing this voluntarily,
Yes, I am.
of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
And if I didn't ask, nobody's threatened you to plead guilty to this charge, is that correct?
No, sir.
All right. Well, hold it. Let's do that. Is it a correct statement that nobody's threatened you?
No, no one's threatening.
There we go. Okay. That last part will be okay. All right. October 22nd, 2023, at the location of 2515 Ellsworth Road, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
Yes, sir.
There, and in that loaded vehicle, was there a firearm?
Yes, sir.
And was the firearm loaded?
Yes, it was.
The vehicle.
Yes, I did.
Okay. And you didn't have any authority to carry or possess that weapon in that fashion, did you?
I have the right to carry a weapon, but I guess without the CPL, I can't have it concealed.
Okay, just listen to my question. In the manner in which you were carrying that weapon on that day, loaded in a motor vehicle, do you have any authority to carry that weapon in that fashion?
No.
Counsel, have I complied with the court? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
January 2nd, 2025 at 10 a.m. with Judge Washington.
January 2nd, 2025, 10 a.m. before Judge Washington.
Got it.
Bond will continue. Thank you.
Judge, does he need to contact probation or will they?
He does. He needs to contact 14B probation.
Very well. Thank you, Judge.
Thank you. Court calls the case, People versus Austin Rowe.
Morgan Poisson for the people.
Good afternoon, Your Honor. William Amadeo, P76194, on behalf of Mr. Rowe. Austin, please state your name.
Austin Donald Rowe.
All right, thank you. What are we doing?
Your Honor, can we have an exam date of December 17th if possible?
I gotta give up today. I'm not even gonna, just giving up. Is all discovery complete?
All discovery is complete. There's also an offer that I need to review with my client that may be beneficial. But as of right now, I do want to set it and the people have fulfilled their obligation on discovery.
All right. Well, the people had their witnesses available since Mr. Amadeo decided to pick his own date of the 17th.
We'll do our best.
Preliminary examination in person, December 17th, 2024, 9 a.m. That is before Judge Valvo.
Thank you, Judge.
Thank you. Bond continued. Court does call the case of the people versus Jesse Rogers.
And good afternoon, Your Honor. Sydney Rushing and appearing on behalf of Ms. Rogers. Ms. Rogers, will you please state your name for the record? Jesse Rogers. Thank you.
Yeah, what would a day be without rushing?
Yes, right? And it's my lawyer-versary.
I know.
Years in the game
You know,
now.
it would be quiet. All right, anyway. I know.
Judge, we would like to schedule this for a preliminary examination for whatever date your honor wants to give us. We won't be picky.
She's so nice. And
Can I
all
get that in writing?
discovery is complete.
Yes, Judge.
All right. And would the people have their witnesses available the 3rd?
We will try, Your Honor. I will let the court and defense counsel know there was a request for some additional videos. I think those are going to be disclosed today or tomorrow, so I feel confident in setting the stage.
All right. Preliminary examination in person will be set December 3rd, 2024, 9 a.m. before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond continued.
Oh, Judge, I apologize. Can we rephrase just fine? It'll take 2 seconds. I have to give you something now, right?
Yeah.
Judge, as part of Miss Rogers' bond, she is currently on a scram tether, and I know that Community Corrections did submit a report to Your Honor showing that there's been no violations. Your Honor, this case does not involve alcohol in any way, and with those negative reports, I'm just asking Your Honor to consider removing the scram tether.
Any response from the people?
Your Honor, my understanding is that their defendant does have a history of OWIs. Involving the theft of a vehicle. That's it. I think it was described to other with the concerns about potential drinking and driving while on bond.
All right.
Your Honor,
I'm gonna deny.
Yeah.
Pardon?
I was just gonna say the prior OWI, Your Honor, was from 2018. She has been sober. She's actually in the process of getting her license back with through the Secretary of State. So I just wanted Your Honor to be aware.
Okay. And what I'm going to do is I'm going to deny the request. We'll keep it on, and you can certainly make that request after the preliminary examination from Judge Freshour.
Okay, thank you so much, Your Honor. Have a great day.
Thanks, Your Honor.
Thank you. Thank you. Court does call the case of the people versus Michael Ware.
After one of the people.
David I. Goldstein appearing on behalf of the defendant. Mr. Ware.
Michael Ware. All right.
Your Honor, I did talk to Ms. Lande today. There is electronic media that has not been provided as of yet. So you're going to ask me if we're ready for exam, and I'm going to say no. So.
Oh, gotcha. Okay. So I'll adjourn the probable cause. How much time?
We already have them. We're just waiting on a copy of Mr. Goldstein's appearance to our office. So.
Got it. All right. Is it a lot of media?
I'm not sure, Your Honor. I don't know.
Would the 12th work for you, Mr. Goldstein?
Okay, I was thinking the 5th, but if that's up.
I mean, I'll do the 5th. I just want to make sure everything gets to you and you
I think
can
that'll be
look
fine.
at.
Yeah. Okay. Let's move this case. Let's move this case along.
December 5th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the case people versus Jashawn Whitfield.
Good afternoon, Your Honor. Melanie Bates from Randall Upshaw's office appearing on behalf of Jashawn Whitfield.
And
Mr. Whitfield.
Jashawn Whitfield.
Got him. Okay. All right. And what are we doing today on this case?
Your Honor, we are going to waive the preliminary exam. We do have discovery.
All right, you're waiving preliminary examination. Is that correct, Mr. Whitfield? You're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Ms. Bates, as to the arraignment, you waive formal reading, stand mute.
Yes, Your Honor, we do.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 PM with Judge Conlon.
January 15th, 2025, 1:30 before Judge Conlon.
Okay.
Thank you very much, Your Honor.
Thank you. Bond continued.
Have a great day, everyone.
All right, thank you.
Just sign the information.
Oh, got it. Court does call the case of the people versus Ramsey Jackson.
That's the line for the people.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Ms. Jackson.
Good afternoon. All right. Ms. Jackson, can you state your name, please?
Brazia Jackson.
All right. I said your name all wrong. I'm sorry. All right. Okay, what are we doing on this case today?
Your Honor, we'd like to set it for exam, please.
All right, all discovery is complete.
I believe so.
All right. And would the people have their witnesses available on the 3rd?
Just have one moment, Your Honor.
Sure.
Yes, sir. We'll try and make that work. Thank you.
All right. Preliminary examination in person will be set December 3rd, 2024, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case of the people versus Kurt Bender.
Ready, Your Honor. Good afternoon, Your Honor. Sanford Schulman, P 43230. Appearing on behalf of Kurt Bender. Mr. Bender is appearing as MI by way of video. Mr. Bender, can you introduce yourself?
You'd probably be better doing it if you unmute.
Hi, Your Honor. Sorry. Kurt Bender.
No, it's okay. All right. Thank you. All right. What are we doing?
Your Honor, today's the time and date scheduled for a probable cause conference. We have all the discovery. We reviewed it. I wasn't sure if Ms. Hughes had extended an offer. We are more than prepared to waive the statutory right to a preliminary exam. I just didn't know if there was an offer at this stage, or maybe that would be coming at the AOI or the pretrial.
If you want to adjourn, you can reach out to me for the next PCC. That would be helpful.
Okay.
All right. I'll adjourn the probable cause conference. What will work better for you, counsel, 5th or the 12th?
The 12th has worked. I'm going to submit and I'll submit a mitigation letter to Ms. Hughes, and maybe we can get it done by the 12th.
Wonderful. Thank you so much.
Okay, so you want the 12th? Is that what you want to do?
Yes, please.
Oh, okay. All right. Probable cause conference, December 12th, 2024, 9 a.m. Bond will continue.
Thank you. Would I need to renew my request for the live stream hearing, or can the order?
Yeah. Well, what you have to do is you have to send it in, make the request, and then I take a look at it. Okay.
Very good. Okay. Thank you.
Thank you.
All right. Thank you.
Thanks, Judge.
Thank you. All right. That's it till 3.
Yes, sir.
All right. I'm good.
You want me to take down?
Court's in recess. Out this.
Okay, you already have your own lawyer?
Yes.
Okay, all right. Do you know who that is? I don't have anyone in the waiting room yet.
Davis.
Maurice
Did
Davis.
speak with Mr. Maurice Davis on this situation. He said he's not on it for this matter. We could talk him for arraignment purposes.
Okay.
And then he could talk to him after arraignment.
Okay, Attorney Davis has requested the attorneys here to speak with you to represent you at arraignment, and he said he'll take over from there. So when I have someone in the Zoom courtroom that meet with you, I will put you in a breakout room with an attorney, okay?
All right.
Alright. Mr. Bird, still with me?
Good afternoon.
Good afternoon, everybody. Okay, let's start on Sherman and then we'll do Greenlaw and then we'll go to DDC. We're on the record. We're on the record. Okay, here we go. All right. Good afternoon. What's your name, ma'am?
Bendy Sherman.
All right. Good afternoon, Ms. Sherman. Calling case number 240-452-5901. People of the state of Michigan versus Bindu Sherman. Counsel.
Yes, good afternoon, Your Honor. Brandon Bird on behalf of Bendu Sherman. My client waives the right to formal reading and we stand mute.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. This is an AG case. I'm assuming the people are not appearing here.
That's correct, Your Honor.
Thank you. All right. Mr. Bird.
Yes, Your Honor, 38-year-old lifelong, not lifelong resident, been here for 7 years now. George. He is a American citizen. He is an American citizen. Non-assault validation. Respectfully ask.
All right, thank you. All right, Ms. Sherman is charged with trespassing at the casino as a disassociated person, having placed herself on the list to be barred from the casino. So I'm not seeing her as a danger to the community at all or a flight risk. I'm going to set the bond at $5,000 personal. Next court date here is going to be a pretrial on December the 5th in front of Judge Jones. You now have a bond condition that you may not go to the Greektown Casino, okay? All right, you'll get some paperwork. Thank you. And then we will go to Mr. Greenlaw. Good afternoon, sir. How are you? What's your name, please? Thank you. All right, Mr. Greenlaw, you've got some traffic misdemeanors where you missed your court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'll set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on these tickets. If you cannot afford an attorney, one will be provided for you on or before your next court date. They are misdemeanors for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. It does not mean that's what will happen in your case. Ticket P1290972 alleges December 15th of 2021 at 7 Mile and Wildermere that you failed to display a valid license. Ticket P1513941 alleges October 24th of 2023 at State Fair in Chrysler driving while license suspended. P1514119 alleges December 5th of 2023 at Hubble in Clarita driving while license suspended. P 1516379, October 31st of 2023 at 7 Mile and Beach, driving while license suspended. And then ticket number 207119861, alleging February 28th of 2020 in the area of 7 Mile and Wisconsin, driver's license expired. All right, on all of these, you have personal bonds, and your next court date on those is going to be a pretrial December the 20th at 9 a.m. in front of Judge Perkins. You'll get some paperwork on that. Now calling case number 240-606-5401, people of the state of Michigan versus Javier Gatlin. Is that you, sir? Please state your name for the record. What? Wait a minute. Nope, you're right. I didn't. I pulled the wrong file. In fact, let me check these tickets. Nope, green law tickets, Gatlin file. What's wrong? Hold on. Is this all, Mr.? This is green law, but Gatlin is in the MIT for Gatlin is in the green law file. That's my problem.
I was missing.
Okay.
I didn't know where.
Okay. All right. Worried me.
So
Okay.
this, he doesn't have it.
Yeah, I need a MIT for green law.
Okay.
All right. Calling case number 240-595-8901, people of the state of Michigan versus Kyle Greenlaw. Counsel.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Kevin Bird on behalf of Kyle Greenlaw. My client waives his right to the formal reading, which violates his constitutional rights, so we stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, the people have no objection to a $25,000 personal bond, no contact. The convictions that I do see for him are weapons offenses. Nothing assaultive in his record that I could find. I would ask for this occurred over a child exchange about 2 months ago. So I'm asking for no contact with Ms. Harris. And if there's any child exchange, that would have to be done through a third party. I would be asking the court to order.
Thank you. Okay, let's take a look. All right.
It appears that he claims to be going around her car and then she claims that he ran into her car and then he hit her car.
After he was trying to leave and she had blocked him in and he was trying to maneuver around it and he hit her car is what he said. And, you know, I don't have the statement from her in the investigator's report. So I was looking because I found it interesting that he ended up charged in front of me this way at all, quite frankly.
Well, I think it might be based on the second time, the second hit. And so they may be adding a count of MDP, but Your Honor, that's why I felt based on, it's more of a trial issue and not a flight or dangerousness, as long as the court has a no contact order in this. He does not have an assaultive background. It appears to be over the child. So I'm asking that, Your Honor.
All right, thank you. Bond is going to be set at $5,000 personal. Are you a CPL holder? Okay, all right. There's a no weapons provision then. All right, you cannot purchase or possess any firearms or other dangerous weapons during the course of your bond, and no contact with the complainant. So exchange is going to have to go through a third party. Okay. All right. Next court dates: December 3rd for probable cause conference, December 10th for preliminary examination, both in front of Judge Giles. Thank you. All right, thanks. get DDC in here. Defense counsel, can you see if we're ready on Smith, Gatlin, and what was my other one? You can go through. Smith, Gatlin, and my third one. Okay, would you see if she's ready? Grover. Okay, thank you. Defense counsel, is anyone available to go into breakout room to interview Mr. Harris?
I am, Your Honor.
Okay, good afternoon, Attorney Martin. I'll get you in there. Thank you.
Thank you.
Okay, Mr. Harris, if you see an invitation to a breakout room, please accept it.
All right.
Hello, DDC. We're with you on the mail side. Good afternoon. Can anyone hear me at DDC? All right. What's your name, sir?
JC.
Okay. Can I get Mr. Grover after this, please? And then, sir, restate your name a little louder, please.
JC.
Thank you, Mr. Hill. Okay. Right, Mr. Hill, you've got a couple of traffic misdemeanors where you missed your court dates. When you missed your court dates, the judges assigned to those cases issued warrants. They set bonds. I'll set the warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say can be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors, which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Doesn't mean that's what will happen in your case. Ticket P1552653 alleges February 20th of 2024 at Terry and Tyler that you disobeyed the lawful order of a police officer. And ticket P1597109 alleges July 4th of 2024 at Hartwell and Chalfanti that you did not have insurance, drove while your license was suspended. On both of these tickets, you have personal bonds, and your next court date is going to be a pretrial December 20th at 9 a.m. in front of Judge Millhouse. Now calling case number 240-606-5601, People of the State of Michigan versus J.C. Hill. Counsel.
Lisa Coyle, appearing on behalf of the people.
Your Honor, Philip Rain on behalf of Mr. Jason, and knew he's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, the people have no objection to a $10,000 personal bond in this matter. The R&O is him running from the police after the traffic stop.
Thank you.
Objection, Judge.
All right, thank you. Charges here have to do with possession of a weapon, but not the use of that weapon in any assaultive capacity, and fleeing from the police, which also is non-assaultive. Seeing no danger to the community, and not equating flight from police as a flight risk as to court. Bond will be set at $10,000 personal. Next court date, December 3rd, probable cause conference, December 10th, preliminary examination, both in front of Judge Giles. Mr. Hill, you cannot purchase or possess any firearms or other dangerous weapons during the course of your bond. Right? Thank you.
Thank you, Judge.
Thank you.
Mhm.
Thank you, Your Honor.
Mhm.
Judge, it's my understanding Javier Gatlin is a female.
Jeffrey Baker.
All right, where's Mr. Grove? You have Mr. Grove? Or Grover. Sir, state your name.
Antonio Lamont Grover.
Thank you. Calling case number 240-606-5701, People of the State of Michigan versus Antonio Grover. Counsel.
Jennifer Douglas for the people, P72748.
Right on behalf of Mr. Grover, waive the formal reading standard, he's been advised of his rights, Judge.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Grover's behalf. Positions as to bond, please.
Your Honor, Mr. Grover, the people are asking for a remand pursuant to MCR 6.106. Your Honor, he is charged with multiple counts of CSE first degree. Your Honor, we believe that he poses a danger to this complaining witness, but also the public. I know the courts had a chance to read the allegations that Mr. Grover allegedly repeatedly raped his mentally disabled aunt, Your Honor, who lived with him. But we would also point out that this is Mr. Grover's third case involving CSE. He has a 1993 conviction for CSE third degree, force or coercion, and CSE fourth degree, multiple variables. And then he has a 2003 conviction for CSE first degree, person under 13. And now he's accused of raping his aunt repeatedly. Your Honor, she has developmental delays to the extent that she actually had to be forensically interviewed instead of just interviewed by the police, Your Honor. And this apparently has allegedly been going on for years. So we do have concerns here that if Mr. Grover has anything less than remand, that the public in general would be in danger given this extensive history of convictions for criminal sexual conduct and combined with this. We're asking for a remand in this matter.
Thank you. Defense.
Judge, I do understand that the charges are serious. We do have priors from 1993, 2003, it's 2024. These allegations alleged to have started in 22 and had continued to 24, but they are allegations. Obviously, we're not trying the case today. This is just an arraignment. He'll have his day in court. He'll have an opportunity to present his case. The people will have their opportunity to present a case to try to show that he is guilty beyond a reasonable doubt. That's not for today. Today, the court has to look at a couple of things, whether he poses a threat to this complainant and the public, and whether he's a flight risk. Now, the priors are from well over 20 years ago. He's going to definitely have no contact with the complaining witness who is his aunt. That is a guarantee in terms of what the condition of bond will be. So now, if you put that together with the fact that, I think that if you say no contact, he'll come to court, Judge. Those two things, I'm asking the court to whatever conditions the court would put on a high personal bond, I'd ask for with tether, house arrest. He's not working. He's receiving Social Security income at this time. So there's no reason for him to leave the house. If he has a place to tether to, which is my understanding he does, then I would ask the court to do so. Again, the dates between these two, there are a lot of questions that have to be answered. I think that, the people, are going to have an opportunity to present their case, and Mr. Grover is going to have an opportunity to defend his case, but not today, Judge. This is just an arraignment.
Thank you. This complaint was actually amended because initially it had years on it, but not months and days, because of the difficulty with interviewing the complainant. However, given the number of priors, this court believes that the defendant's dangerousness reaches the entire community. not just his aunt. And so this will be a remand being available because the charge is CSC in the first degree. Mr. Grover is remanded to custody. Next court date, December 3rd for probable cause conference, December 10th for preliminary examination. Both will be in front of Judge Sabri. There is to be no contact or attempted contact with the complainant in this case. That means no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact will be considered a violation of the conditions of the bond. All right, thank you. Madam Clerk, remand paperwork, please.
Okay.
Thank you. If you have Smith and Gatlin, or I understand Gatlin is on the female side, so we'll get that over there, do that over there.
Oh, you do? Yeah. Jeffrey Baker.
Okay. Hearing me? May I have Mr. Smith after Mr. Baker, please? Okay. Calling case number 240-556-2401, people of the state of Michigan versus Jeffrey Baker. Counsel.
Judge Steve Benson, P71917.
Your Honor, on behalf of Mr. Baker, waive the reading stamp mute. He's been advised of his right, Judge.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Baker's behalf. Officer Tompkins, do I have an information sheet on Mr. Baker? Position says to bond, please.
Judge, it's a child support case. Apparently, it's an offense date of May 1st of 21. The warrant was issued this year, about 3 years later. I think the statute controls this. We're not going to be objecting to a personal bond if good cause is shown by defense counsel.
Thank you. Government is requesting $5,104.49 cash bond in accordance with the statute. Is there good cause that I should not impose that as a cash bond, counsel?
Judge, it is. My client can't afford that. He is employed, Judge, but he can't make that bond based on what he makes, his income at this time. He did have some money coming out of his check for child support, thought that it was being covered. But again, Judge, he can't afford the arrears at this time. So I would ask the court to use that as good cause for setting a personal bond and deviating from the statute.
All right, thank you. Court does find good cause to deviate. Bond is imposed in the amount of $5,104 personal. So your next court date is going to be January 3rd for probable cause conference. What's going on here, guys? This is assigned to Judge Jefferson, which is inappropriate because this is a child support case. I need dates and judge, please.
Because of the holiday, that was doesn't do it. Like, it's the judge record from now until sometime in January. It's like the second week in January.
That doesn't make any sense. So he's going to go before a district court judge rather than a circuit court judge?
Yeah. They do it.
What's see, Judge?
All right. Next court date. Okay. Oh, okay. So the January 16th for the prelim is going to be changed to circuit. Is that correct?
Yeah.
Okay. All right. Thank you. January 3rd, probable cause conference in front of Judge Jefferson. I have a preliminary examination date of January 16th. You'll double check that with Judge Jefferson when you're in there on the 3rd to see where you need to be and who you need to be in front of on the 16th, because you'll be over at circuit court. All right. Thank you. Personal bond. Remand. Okay, I'll take that. Thank you. Hi. All right, Mr. Smith, good afternoon. Calling case number 240-606-6801, people of the state of Michigan versus Terrain Smith. Counsel.
Jennifer Douglas for the people, P72748.
Right on behalf of Mr. Smith, waive the reading stamp mute. He's been advised of his rights, Judge.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Arguments, Esteban.
Yeah, Mr. Smith, the people wouldn't object to a $35,000 personal bond. We'd ask for no contact with budget rental. Mr. Smith has a lack of criminal convictions. He did pull the vehicle over when police activated their lights. So we do not believe that there is a flight risk. So we have no objection to a 35,000 personal on this case.
No objection.
Thank you. Thank you. Right, no prior assaultive convictions, at least felony convictions that this court can see, nothing having been used to enhance finding no danger to the community here. Nothing to indicate flight risk. Bond will be set at, what was your request from the people?
35,000 personal.
All right, bond will be set at $35,000 personal. You may not go to budget rental car. Don't go back there if you were there. All right, $35,000 personal. Next court date, December 4th for probable cause conference, December 10th for preliminary examination. Both of those are in front of Judge Taylor. Mr. Smith, you may not purchase or possess any firearms or other dangerous weapons during the course of your bond. Thank you.
Okay.
Thank you. Your Honor.
Thank you. Christopher Jordan Blair.
One moment, please. DDC, after this, do you guys have the capacity for us to go over to the female side to do Gatlin? Repeat your name, please, sir.
Christopher Jordan Blair.
Thank you, Mr. Blair. Case number 230-559-4601, people of the state of Michigan versus Christopher Jordan Blair, counsel. Information sheet, please. Officer Tompkins.
Your Honor, this appears to be an AG case.
Thank you.
Thank you.
Celebrate on behalf of Mr. Jordan Blair, Your Honor. The way the formal reading stand mute, he has been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. People are requesting bond in the amount of $1,323.15 cash in accordance with the statute. Any reason I should deviate?
Yes, my client is unable to pay that bond at this time. He's a CNA, can't afford that particular arrears. I'm asking respectfully for the court to deviate from the statute and set a personal bond at this time.
All right, thank you. Bond will be set in the amount of $1,323 personal. Next court dates are going to be January 3rd for probable cause conference. That one will be in front of Judge Taylor. After that, January 16th is the date set for preliminary examination. They'll let you know where and when exactly you need to be when you're at that January 3rd appearance, okay? Thank you. Personal bond. Thank you. Defense counsel, would you please see if you guys have completed the interview with Gatlin and then ask them if so to release the female camera so I can do that arrangement?
We're trying to get them to bring her to the camera. We can't get anybody to bring her to the camera.
All right, thank you. DDC? I don't know who's over there today. I'm sorry, you're out of camera view. Can you guys hear me at DDC? They may have gone over to try to deal with that.
Yeah, we're trying to go over there and deal with that right now.
Perfect. Okay, thank you so much. All right, so I'll wait a moment. Yeah, I know that you guys need to do the interview, right? For Gatlin.
Right, we want to just keep.
I need to get Gatlin done fairly quickly, so whatever we can do to get that individual to the camera would be appreciated. Thank you. And then we can keep going on this side if you guys are adequately staffed to do.
DeAndre LaBelle Cullen. Hey, how you doing?
Good, thank you. All right, Mr. Coley, calling case number 220-596-9301, people of the state of Michigan versus DeAndre Coley, counsel.
Jennifer Douglas for the people, P72748.
Deliberating on behalf of Mr. Coley, Your Honor, waive the reading stand muties.
Oh, I'm sorry, Your Honor. This is a felony KPS, so the city
Yes,
won't be
it is.
appearing.
Okay, thank you. Go ahead with your appearance, Mr. Reagan.
Deliberating on behalf of Mr. Coley, Your Honor, waive the formal reading stand mute. He's been advised of his rights.
Thank you, counsel. Court notes formal reading has been waived. Interest in not guilty plea on your client's behalf. There is a KPS bond here for $1,000, 10% for defendant's failure to appear at the probable cause conference. Has that been addressed, counsel?
It has, Judge. We did a motion, got a response for personal bond. I would ask that the court grant a personal bond.
All right, thank you. Given that information, charge here is CCW. Court will set a personal bond. Looks like I set the personal bond before, Mr. Coley, at $1,500 personal way back. Me, Mr. Court date. Make sure you get, don't talk. I don't want you to say anything that counsel doesn't want you to say. I'm just noting that I'm the one that set the personal bond way back. I'm gonna up it to $5,000 personal. Do not miss your court date. Not seeing any dangerousness to the community here, given the nature of the charge is CCW in terms of flight risk. We'll give you another shot at that. $5,000 personal. Next court date, December 2nd for probable cause conference in front of Judge Robbins, December 9th for preliminary examination in front of Judge Giles. You may not purchase or possess any firearms or other dangerous weapons during the course of your bond. All right, thank you, Mr. Coley.
Thank you. Chief Cody Timothy Williams.
All right, Mr. Williams, good afternoon. Calling case number 240-606-5801, people of the state of Michigan versus Artiste Cody Timothy Williams. Counsel.
Thank you, Judge. Steve Ensign for the people, P71917.
Your Honor, deliberating on behalf of Mr. Williams, waive the reading stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Positions as to bond, please.
Judge, this defendant has a lot bigger things that he's dealing with other than this potential straight 5-year sentence. It looks like he has a parole violation out of Nashville, Tennessee. He's waiting extradition. He's got a $100,000 bench warrant out there for possession of meth with intention to manufacture or deliver. And then he's got potentially a parole violation here because he's on parole for an armed robbery as well as an FF that he doesn't get off of parole for until next year. So it doesn't appear as though this defendant's going anywhere anytime soon. He's not a flight risk or a danger. We're just going to be asking for a personal bond.
No objection to personal bond.
Thank you. All right. Charges here have to do with possession of a firearm, and we've got a charge of assaulting, resisting, obstructing police, given the people's request and defense counsel's non-objection to that. Bond will be set at $20,000 personal. Next court date, December 2nd for probable cause conference, December 9th for preliminary examination, both of those in front of Judge Jefferson. Mr. Williams, you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Thank you. Please let me know when if you know, Reagan, let me know when they're done with the interview on Gatlin, please, so I can jump over there to do that.
Yes,
all
ma'am.
right, you are Davion Watson Jones, is that correct?
Yes, ma'am.
Was that a yes?
Yes, ma'am.
All right, thank you. Mr. Watson Jones has two cases in front of me. Any objection to my calling those together?
No objection, Your Honor.
No, Your Honor.
Thank you. Calling case number 240-606-6001, People of the State of Michigan versus Davion Watson Jones. That one, a felonious assault combined with domestic violence. Calling case number 240-606-5901, People versus Davion Watson Jones. This one, 2 counts of felonious assault combined with 1 count of domestic violence. Counsel, appearances, please.
Good afternoon, Lisa Coyle, appearing on behalf of the people.
Reagan, on behalf of Mr. John, Watson Jones, the reading stand mute, he's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, the people in this matter are asking for, on both cases, a $50,000 cash surety, tether, house arrest, and for the following reasons. Currently, he is on HIDA probation out of the Third Circuit Court for resisting and obstructing. His probation doesn't end till August 12th of 2025. I will start with this complainant, Ms. Banks. She has a child in common with Mr. Watson Jones. I do note that he was arrested 3 times in the past year for assaulting the complainant. He had just got out of jail for assaulting the complainant. He went home and he hit her with a baseball bat in the face. Officers observed blood coming from her lips. The second case, which occurs the following day, which is also a felonious assault, but this involves a second complainant, Mr. Chambers, in which the defendant allegedly came to the house, threatened her with a knife as well as him. They were asleep in the bedroom, and he came in swinging the knife at the complainant's chest, causing a laceration. And he left saying, "Be here when I come back." So obviously he didn't like the fact that I don't know what this relationship is between Mr. Chambers and Ms. Banks, but they're in the same bedroom, so I can make assumptions. I do note, Your Honor, these are highly assaultive within a short time period. He has been arrested 3 times for assaulting her, and he was also arrested on November 16th. So these are very close in time, very volatile. This is a situation not of a flight risk, but of a danger to the complainant in this matter, Ms. Banks. Whether she proceeds or not, that is up to her. But at this point, Your Honor, police have observed injury to her. There's injury to Mr. Chambers. Mr. Chambers is, per an APA note, for sure going forward. He is currently on probation for under HIDA status. Your Honor, he's 22 years old. This is a situation which I think is highly volatile. This is 2 days ago, and for the one case 3 days ago, and then a third that occurred on the 16th per an APA note. Your Honor, I'm asking for the high bond for the protection of the complainant in this matter.
Thank you.
Thank you.
Judge, and maybe I misheard this. Ms. Court, did you say you had 3 other arrests outside of these other arrests for allegedly assaulting the?
Yes.
Okay.
There was an APA note dated the 20th. Defendant arrested 3 times for assault to complainant. And I believe that's including the November 16th, the 18th, and the 19th.
Okay, so it would include.
Because he was in jail on the arrest on the 16th. He gets out of jail, and that's when it appears that he came back and assaulted her with a baseball bat on the 18th. And then the next day is the assault on the 19th. So there's the 3 times that my understanding. Okay. Thanks.
Okay, I was trying to make sure that it wasn't 3 other times outside of these cases. That's what you were trying to say. Judge, it's obviously, time for a new, relationship, new situation. This is not really working well with Mr. Watson Jones and Ms. Banks. So separation is definitely a condition. I know that you're going to do that. He's not going to have contact with her. He's got to deal with his probation issue. As Ms. Coyle says, he's on HIDA probation. That's going to be something that he'll have to deal with. I don't know what the ramifications will be by just being charged. Now, I don't know what's going to happen with these cases. They're just charged right now. I don't know if she's going to show. I don't know what the situation will be. I just know that it's no contact. I don't think he has any prior cases of this nature. Judge, he's not working right now. He lost his job, actually. They do have 1 child together. So that at some point they're gonna have to deal with each other, and obviously not anytime soon. But I am asking the court for a GPS tether, full home confinement. It's 22, no history of this type of behavior, to my knowledge, not charged history at least. So I'm asking for personal with those conditions.
All right, thank you. Ms. Coyle, did you say that one of these allegations occurred after a release on another
Yes.
case?
Yes, and he was arrested on November 16th.
We don't have that charge.
So-
Judge. I don't know why.
No, it's not charged.
So he was arrested on November 16th for domestic violence allegations, and he was released. And then we have allegations that there was another assault on the 18th and the 19th.
That's correct. Going back to the note too.
All right.
I'm not sure I understand that, Judge.
What do you mean you don't understand?
Well, in terms of why he was arrested on the 16th, not charged on the 16th. He was arrested for something that happened 2 days in the future.
Sometimes it requires a complainant to go forward, Mr.
But I'm saying the
Well, then
allegations.
that's why I think
the
that's,
allegations would have been on the 16th, I would think, and not the 18th. It's the
My
same.
understanding is that we're talking about another case. So they were called and arrested him on the 16th. No charges resulted from that. He gets released, he goes home or gets out, and then she's alleging that he's assaulting her again on the 18th and the 19th. That's pretty clear to me.
But no charge on the 16th, Judge. I've seen them go back 6, 7, 8 months to charge a case that they, on the day of a new case, that they will bring a case
Well,
back.
I mean, right, so,
Why
okay,
wouldn't they
so
bring
then
it-
what you're asked, what
Yeah.
your point is then that perhaps the charge, the allegations on the 16th were not credible enough to pass a probable cause determination.
Exactly.
Okay,
Why?
thank you.
That's all.
Thank you. Right. In these two cases, I have a complainant who has visible injuries. That's a concern. I have an allegation on one day that she was hit with a baseball bat and she's got bleeding or from the lip that police observed. And then very close in time, I have allegations that she is cut with a knife and a laceration is observed. So, you know, there's evidence that what the complainant says happened here happened. You know, I understand that, you know, she may not be as cooperative or moving forward, but I am going to set a cash bond so that she feels comfortable participating in this process, should she need to do so. Bond is set in each case at $25,000 cash surety. If he's able to make the bond, he must be fitted with a GPS tether before release, so that we can know if they, at least try to know if they've been in the same place or if he's gone back to the address where she resides.
Your Honor, I'm going to answer your question. That there's an APA note, November 17th, was denied because they were unable to talk to the complaining witness, that her phone
Okay.
was not accepting calls. So I just wanted the record to be clear. There was a warrant presented, but denied based on that basis.
And let me be clear,
Thank you.
Judge. They talked to her the 18th, so they could have went back and talked about what happened on the 16th.
Don't care.
I know. I'm
So let's just simplify this.
I know.
I'm talking about this case and this case where police have observed injuries to the complainant. Bond is set at $25,000 cash surety. There is to be no contact or attempted contact with the complainant in this case. And sir, you may not go back to the address on Finkel where this is alleged to have occurred. You will be fitted with a GPS tether before leaving the jail to ensure that. You are also not to purchase or possess any firearms or other dangerous weapons during the course of your bond. December 2nd for probable cause conference, December 9th for preliminary examination, both dates in front of Judge Sabri. All right, thank you.
Thank you.
Mr. Gate, what is that correct?
Yes, we're done. Done with
Thank you.
Javier Gatlin, Your Honor. Done with Javier Gatlin.
Okay, we'll do Mr. Gatewood and then we'll go over to do Gatlin. Or actually, let me see if I can get Gatlin now. Just one moment so that I'm not holding up that camera because I'm assuming you guys have other women to interview. Okay, ask them to release the camera in a minute or so, please, Mr. Reagan. I'm gonna get through Mr. Gatewood and then I'd like to get Gatlin done. All right, calling case number 240-606-6201, People of the State of Michigan versus Javier Gatewood. Counsel.
Steve Benson for the people.
Right, on behalf of Mr. Gatewood, waive the ring stand mute. It's been advised it was right.
Thank you, counsel. Court notes formal reading has been waived. Interest in not guilty plea on Mr. Gatewood's behalf. Charge here is CCW. Positions as to bond, please.
Recommending personal.
No
Thank
objection.
you. Thank you. Bond will be set at $5,000 personal. Mr. Gatewood, you are not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Your next court date is going to be a probable cause conference on December 2nd in front of Judge Robbins. After that, you have a preliminary examination set for December the 9th, right? Both that second one in front of Judge Giles. Not to purchase or possess any firearms or other dangerous weapons during the course of your bond, set at $5,000 personal. Thank you. Okay, one moment on the male side. I'm going to jump over to do Gatlin on the female side, just putting you in the waiting room for a moment. Hello on the female side. May I get Javier Gatlin, please? Javier Gatlin. Can you hear me on the female side? Right. Good afternoon. Name, please.
My name is Javier Gatlin.
Thank you. All right. You do have some traffic misdemeanors where you missed your court dates. When you missed your court dates, the judge assigned to those cases issued warrants and they set bonds. I'll set the warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say may be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Does not mean that's what will happen in your case. Ticket number P1192941 alleges May 2nd of 2021 at West Chicago and Archdale driving without a license and no insurance. P1467591 alleges June 9th of 2023 at Greenfield and Ellis, no registration, no insurance, no valid license. P1592338 alleges June 17th of 2024 at Woodward and Alfred, unregistered vehicle, license suspended, no insurance. P1609314 alleges August 5th of 2024 at Myers and Schoolcraft, unregistered vehicle, no insurance, license suspended. On all of these, you do have a personal bond, and your next court date is going to be a pretrial at 9 a.m. December 20th in front of Judge Perkins. Now calling case number 240-606-5401, People of the State of Michigan versus Javier Gatlin. Counsel.
Thank you, Judge. Steve Benson for the people.
Deliberating on behalf of Javier Gatlin, Your Honor, waive the formal reading, stand mute. Been advised of their rights, Your Honor.
Thank you, counsel. The court notes formal reading has been waived. Interest in not guilty plea on Ms. Gatlin's behalf. Positions as to bond, please.
Judge, it's a serious offense. It's non-assaultive. It appears as though this is the complainant's neighbor. Apparently, she's a daughter to another individual that lives close. She's the one that allegedly ended up throwing this flower pot through the neighbor's window. I have October 9th of 24. I have a retail fraud third degree out of Livonia that was deferred under HIDA. With all of that being said, Judge, I think there just needs to be separation between this gal and the complainant. So a no contact through the pendency of the case, and then we wouldn't be objecting to a personal.
Thank you.
There's no objection to personal. I think that it's a prior former neighbor now at this point. So as Mr. Vincent said, no contact. I think that would suffice at this point, Judge. No contact.
All right.
It just happened 3 days.
I mean, I don't know. It's my understanding that there's a former neighbor.
Do I need to make Ms. Gatlin go stay someplace else?
She no longer resides next to the complaining witness, is my understanding. That's why I said former. So she is actually staying somewhere else, Judge.
I think Mr. Reagan, though, I think he can understand my concern, because on the investigator's report, it showed that she was living at that address. I mean, I'll take you at your word, but there are indications that show she was living there. So that's.
All right, well, listen, I'm going to impose a do not go, Mr. Reagan, so onto the block. So you wanna voir dire her just as to yes or no as whether or not she resides there and needs somebody to get her things?
No, Judge. So in my notes, it's my understanding. I mean, and as Mr. Vincent said, she may have very well been there on the question, but as of today, she no longer resides next to the complaining witness. Is that correct, Ms. Gatlin? You do not reside next to the complainant?
That is correct.
So should be no reason for any contact.
All right, thank you. Thank you. All right, given the people's position and defense counsel's not objection to the personal bond, we'll do a $20,000 personal bond. I'm not going to order a tether, but I do not want you going back onto the 2600 block of Griggs over there. Don't go back onto that block until a judge says otherwise. All right.
Thank you. Thank you.
Next court, you're welcome. Next court date, December 2nd for probable cause conference. Hold on, she needs court dates.
I'm sorry, I do apologize. I thought you were done. I'm sorry.
It's okay. Come on back, Ms. Gatlin. Everything's okay. All right. December 2nd for probable cause conference, December 9th for preliminary examination. Those are both going to be in front of Judge Jefferson. All right. No contact or attempted contact with this complainant. No verbal contact, no written contact. No contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of your bond. I see your hand was raised. You have a question about the amount of your bond, the conditions of your bond, or your court date?
I was just making sure, seeing if I would I be able to look up the court date just so I can have it in my phone, or would it be mailed to me? That was all.
Go to the 30.
They'll give you.
Go ahead. I'm sorry.
Yep. Yeah. Okay. They'll give you some paperwork.
Okay, thank you.
All right, thank you. All right, we'll go back to the mail side. Thank you.
Your Honor?
Little too happy.
Yes.
All we have is one more female, Ms. Brown.
Oh, is she ready? If she's ready, we can stay here.
We're ready.
Hi, what's your name, please?
Jeanette Brown.
I'm still working on Watson Jones. I'll have it for you in a minute. All right, Ms. Brown, good afternoon. Calling case number 240-606-5501, people of the state of Michigan versus Janet Brown, counsel.
Jennifer Douglas for the people, P72748.
On behalf of Ms. Brown, waive the reading standing. She's been advised of her rights.
Thank you, counsel. The court notes formal reading has been waived. Interest in not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, on this Brown, the people wouldn't object to the 35,000 personal, but we are asking for a tether with a curfew because we do have some safety concerns here. The police were originally actually responding to a person shooting in the air, and I did send defense counsel an incident report for Ms. Brown that gets a bit more detail about that. They give a description, including clothing, and that it was a Black female with short blonde hair, Your Honor. And that when they got to the location and they ended up seeing Ms. Brown, she matched that description of the clothing that was being worn. So given that there was the firearm found as well as spent casings right next to her vehicle, that gives us concern about the safety of the public. I don't know what the current status is for the mental order that's referred to in the investigator's report. I know the investigator's report says that it is still current. That statement ends up saying that she may intentionally harm herself or others. However, it is from 2010, so I'm not sure what state of that is, because I did try to go to the probate court website to look it up, but wasn't able to find it, Your Honor. So I don't know what ended up happening there. But given that there's the allegation of shooting, that casings were found next to her vehicle, that she matched the description that was given when someone called the police. I am asking for teller and a curfew, but I don't see any convictions for Ms. Brown since 2003 that involved retail fraud. And before that, it was 96 with the aggravated assault. So she hasn't had any convictions in a while, but the allegations do give us some concern.
Thank you. Defense?
Yeah, Judge, honestly, Your Honor, I look at the allegations and the complaint felon. That's really kind of the only ones I look at, because that's what they're being charged with. I do understand there's an investigator's report that talks about possibly what happened is hearsay. It's not admissible. So I don't know how accurate it always is, but I do understand the court looks at that. I understand that that's something that is used in terms of setting bond. I'm asking, she's charged with the one kind of concealed weapon in a motor vehicle, commission of a motor vehicle advisory. So I'm just asking for the personal bond, Judge. Obviously, no contact with any weapons of any form or fashion.
Thank you. The sole charge here is CCW. She's not charged with discharge of a firearm or anything like that. I don't know why the people chose not to charge in that way, but it's not charged in that way. Perhaps because it sounds like her boyfriend was also present and she was accusing him of having had possession of the gun at some point, having stolen it from her was her position. So I'm going to treat this as a regular CCW case. Bond is going to be set at $10,000 personal. Ma'am, you are not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Your next court date is going to be December 2nd for probable cause conference in front of Judge Robbins, December 9th for preliminary examination in front of Judge Taylor. Thank you.
I'm sorry, what were those dates? I apologize.
2nd and the 9th?
Thank you. Judge, could you ask DDC to bring the rest of the mails to the camera after I appreciate it.
Yes. Yes.
Number 16 is in the hospital and there's an officer.
Is that Binkley? Because I have a person in the waiting room. All right. Thank you. All right, we'll get them in. Okay, so hello again on the mail side. Thank you for waiting. And then they're asking if they can get the rest of the mails to camera 4. They're trying to interview on camera 4. All right. Let's do Mr. Binkley and then oh, he needs to be interviewed. All right. Let's get the breakout room closed. And who can I send in with Mr. Binkley to the breakout room, please? I've got an iPhone in the waiting room, but it's unidentified.
Hold on 1 second, Your Honor. I appreciate it. We're going to get that done right.
Thank you. All right. Sir, at the DDC, what is your name?
Damon LaDon Watson, and I have a brief statement I'd like to begin with.
No, Mr. Watson. No, stop. Wait until the attorney is back in the Zoom courtroom, please.
Yes.
Quiet.
Yes.
Okay, Mr. Reagan, you want to advise your client he would like to make a pre-statement?
I'm sorry, sir, you don't want to talk right now. Just hold on.
This is Mr. Watson, Damon Watson.
Yeah, Mr. Watson, we want to just remain silent right now. We haven't even started the case. Let's remain silent, Mr. Watson. All right? Or do we need to go in the breakout room?
Okay. All right. Sir, are you just yes or no? Are you Damon Watson?
Yes.
Thank you. Calling case number 240-459-8801, people of the state of Michigan versus Damon Watson. Counsel?
Thank you, Judge Steve Benson for the people.
I'm bringing on behalf of Mr. Watson, Your Honor. Waive the formal reading, stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Judge, I'm not going to be objecting to a personal bond if everybody agrees that we should have no contact with the complainant or the address, that this defendant can't drink during the pendency of this case, and he needs to take all of his prescribed medication. If we can get conditions for all of those, I have no objection to a personal.
Yes, and I don't drink lately.
Mr. Watson, your attorney, just one moment, okay? Let's let your attorney answer and then you'll have a chance.
One of the things, Judge, I believe that is correct. Mr. Watson should not drink. He states he does not drink. So that is good. That is good. We don't have to worry about drinking because he doesn't drink. That's a condition. No contact is another. Now, I would note that, right now, that's where he was staying. Got to get another place. Now, he won't have his check. He doesn't get his check until the first of the month, Judge, and then he's going to go stay at a hotel. So he may have to go to a shelter now. But I know that the court is going to want no contact. But I just want to point that out to the court that he doesn't have a place right now. So we are asking for the personal bond with the conditions. But I just want to just be clear with the court what his situation is right now, Judge, from a financial standpoint, and his ability to go and find a new location to stay.
But you are asking for a personal bond?
It might be better for cash then.
I'm asking defense counsel, please, one
I'm
moment.
sorry. I'm sorry.
That's okay. Is your request still for a personal bond?
Absolutely it is, Judge, because he's going to have to make arrangements. I think no contact is the biggest condition, but that's up to Mr. Watson. He's got to make sure that he has the no contact.
All right, thank you. And then Mr. Vincent, in light of what was disclosed, you had an additional request?
No, I just didn't know where Mr. Reagan was going with the whole living conditions. If we have a no contact, he's living there, he can't go back. I mean, I wasn't objecting to the personal, so I just didn't understand where he was going.
Thank you. Bond is set at $20,000 personal. Sir, you may not go back to the address where this is alleged to have occurred, and there is to be no contact with the complainant. That means no verbal contact, no written contact. You can't even try to contact them through social media, third parties, none of that, all right? And you cannot purchase or possess any firearms or other dangerous weapons during the course of your bond. Your court date's going to be December 5th for pretrial in front of Judge Jones. Okay, thank you. All right, let's get Mr. Harris done. Okay, Mr. Harris has two cases in front of me. Any objection to them being called together?
We're not gonna object because they're felony capiases, and I think he already posted on them, but we're not gonna be appearing.
Thank you. Mr. Reagan, do you have anyone available to go into the breakout room with Mr. Binkley yet?
Judge, we thought Mr. Binkley was at the DDC. We see now he is not. We're just finishing up our last interview for Mr. I believe Mr. Jones, and then we'll be able to jump right into Mr. Young. I'm sorry, and then we'll be able to jump right in with Mr. Binkley, Your Honor.
All right, thank you. Calling case number 200-597-4701, People versus Jamil Harris. This one is a CCW. And then I've got case number 230-606-6101, People versus Jamil Harris, also a CCW. Counsel. Sounds like the people are not appearing on this.
Oh,
thank you.
I'm sorry, Your Honor. Philip Reagan on behalf of Jamil Harris as to both matters. Make the formal reading stand mute. He's been advised of his rights, Judge.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Both of these files contain a felony capias that's already been posted. Is that correct?
Correct, Judge. They were both 1,000, 10%. He did post the bonds of $100. It states that in the ROA, and he's gotten a Zoom day today.
All right, thank you. Then we will simply continue the bond that's already been posted, $1,000, 10%. On both cases, and on both cases, the next court dates are December 2nd for probable cause conference in front of Judge Robbins and December 9th for preliminary examination in front of Judge Jefferson. Mr. Harris, you may not purchase or possess any firearms or other dangerous weapons during the course of your bond. All right, thank you. DDC, we're ready.
Judge, we did give Mr. What's that gentleman's name? With the 2 cases, we gave him a redetermination hearing for Monday, right? Mr. Watson.
Yes.
Okay, great. Thank you, Your Honor.
Thank you.
I'm all done.
You're all done, Mr. Harris. Have a good day.
All right, thank you.
Thank you. All right, at the DDC, what's your name, please?
Montavious Sanders.
Say your first name again, please.
Montavious.
Montesian. Okay, thank you. All right, you've got, Mr. Sanders, you've got some traffic misdemeanors where you miss court dates. When you miss your court dates, judges assigned to those cases issued warrants, paid set bonds. I'll set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and/or a $500 fine. Does not mean that's what will happen in your case. Ticket number P1120489 alleges October 8th of 2020 at Gratiot and Mac that you drove an unregistered or untitled vehicle. Ticket P1212504 alleges June 17th of 2021 at Joanne and Lappin failure to display a valid operator's license. P1381939 August 19th of 2022 at Gratiot and Tacoma driving while license suspended. P1386788 September 3rd, 2022 East St. Fair and Anvil. No proof of driving while license suspended. P1517284 November 4th of 2023 at Midland and Ardmore, driving while license suspended as a repeat offender, no insurance, and unregistered vehicle. On all of these, you do have personal bonds, and your next court date is a pretrial, December 19th at 9 a.m. in front of Judge Archer. Now calling case number 240-606-6501, People of the State of Michigan versus Lytasian Sanders. Counsel.
Lisa Coyle, appearing on behalf of the people.
Right, on behalf of Mr. Sanders, reading statement, he's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on Mr. Sanders' behalf. Positions as to bond.
Your Honor, I do know this is highly serious in which the complainant in this matter was shot in the shoulder. Her injuries resulted in injuries to the lungs, the rib, the chest. The only thing I see from Mr. Sanders is a 2019 disorderly taken under HIDTA status. This is a 2-year offense. I do note this happened on November 7th. It wasn't issued until the 21st, but I do note that the police officers did not present the warrant until the 19th, probably based on, as we read the IR, the following up on all the physical evidence as well as the statements and speaking to Mr. Sanders as well. The people in this matter are asking for a $20,000 cash surety. Tether house arrest if he's able to make that bond, Your Honor, based on the fact that I know it's only a 2-year, but a person had been shot because he felt the need to get out of the vehicle and begin a retaliation type of shooting. And I do know there's a 3-year-old sitting in that vehicle, in which is the complainant had gotten shot and that had been fired upon. So this is gunfire in which more people, including a child, could have been hurt. This doesn't appear to be an argument that he was involved in, but he got out of the car and started to discharge his weapon. So, Your Honor, based on that, I'm asking for that cash surety, tether house arrest. And I don't know if he knows any of the people that were involved in any of this shooting. So,
All right.
Ms. Robinson, he does.
Okay.
Thank you.
Thank you.
Judge, so I look at retaliating shooting as defending shooting. And then you can kind of look at the different reasons. If somebody's shooting at you and you maybe shoot back and you're trying to defend and you're worried about getting shot. And I'm not saying that's what happened, Judge. I'm just saying that I don't think this was a purposeful, shooting it or injuring someone based on the actual charges that the people came up with once they investigated it. As Ms. Coyle stated, it was alleged to have happened on the 7th. They took the time to investigate, and on the 21st, finally the warrant was signed, and it was signed as a 2-year high misdemeanor. And I think there were some factors that made him do that. I don't think that he's a danger. I think if you say no guns, I think that would suffice. I mean, obviously it has to play out in court when it goes through the process, Judge, but no guns, Judge, and I think that would suffice in this particular case. So I'm asking for personal bond, Judge, with absolutely no weapons. Do not possess weapons, Judge. I think that's the biggest thing here. Without weapons, you won't have any retaliation or retaliative shooting going on.
Okay, one moment, please. What's your client's work situation?
Judge, he works as a landscaper. Has one child. So, I don't know. What are your hours, your work hours, Mr. Sanders?
I work from the sun up, basically the sundown. I also do home health care for my girlfriend. She's sickly. She has kidney failure. So I technically have 2 jobs. One I get paid for doing landscaping, and then one I get paid for actually with the check for taking care of my girlfriend.
Thank you. Thank you. All right. Yeah, I mean, my problem with this is this appears to be a dispute that's escalating now to gunfire. Are you going in with Mr. Binkley, Ms. Bijan?
Yes, Your Honor. Thank you.
All right, thank you. For Binkley, please accept the invitation to the breakout room. My problem is that this investigator's report indicates to me that there is more going on and that it's escalating, and that is causing a danger to the community, which has now resulted in someone suffering very serious gunshot injuries. I have the investigator's report indicating that defendant made an excited utterance stating, "Y'all embarrassing me because I was protecting myself after getting shot at the other night." I have other information in the investigator's report about people texting about a physical altercation that had occurred at the property. Something else is brewing here. And it's brewing in a dangerous way that has already resulted in injury. So I am going to set a cash bond and he'll be able to get a redetermination hearing. $20,000 cash surety. GPS house arrest if he makes the bond. Not to purchase or possess any firearms or other dangerous weapons during the course of the bond. Bond redetermination date in front of Mechanico, Monday. Madam Clerk, can you give me the date on that? Thank you. Bond review will be on Monday, the 25th in front of Mechanico. After that, we have probable cause conference set for December 3rd, preliminary examination set for December 9th. In front of Judge Jefferson. Mr. Sanders, you're not to purchase or possess any firearms or other dangerous weapons during the course of this bond. All right, thank you.
Judge, can you clarify for me? Because I'm probably so confused right now. So you're saying that it's escalating and my client is escalating it because he's the one being shot at and he's worried about somebody killing him. I'm trying to understand. I'm trying to understand.
Reagan.
No, I'm
Reagan.
trying to understand.
He's in front of me because he discharged a firearm and someone ended up shot in the hospital.
But after
So no.
after he was shot up, but somebody he knows, right, Your Honor? Somebody that he accidentally, it was an accident, somebody that was with him when he was returning fire when somebody was shooting at him. Right?
Because he's getting out of a car and firing a weapon. He's in a car with the ability to flee, with the ability to move, with the ability to leave.
How if you're in a car? If you're
Instead of that, he allegedly gets out of the vehicle and decides to return fire.
Well, he doesn't get shot. He's sitting in a
Bond
vehicle.
review. Thank you. I've heard your argument. Bond review, November 25th. All right, in front of Mechanico, where you're free to make it once again.
Thank you very much, man.
Okay. What's your name, sir?
Pace.
I need you to speak up, please. What's your name?
Malik Pace.
Oh, okay, thank you. Calling case number 240-606-6601, people of the state of Michigan versus Malik Pace, counsel.
Events for the people.
Yeah, right, on behalf of Mr. Pace, waive the reading stand mute, has been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond on the CCW, please.
Recommending personal here.
No objection.
Thank you. All right, thank you. All right, seeing no danger to the community or flight risk indicated here, bond will be set at $5,000 personal. Sir, you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Next court date is going to be in front of Judge Robbins for probable cause conference, December 2nd. After that, preliminary examination set for December 9th in front of Judge Taylor. Thank you.
Thank you, Your Honor.
Okay. Got three more? All right. What's your name?
Pace Young.
Okay. You have Mr. Lupo there too? If you have Mr. Lupo, he can come on up at the same time. Thank you, sir. State your name.
Robert Lupo.
Thank you. Calling case number 240-606-6702, People versus Chase Young, and case number 240-606-6701, People versus Robert Lupo. Counsel.
Lisa Coyle appearing on behalf of the people.
Deliberating on behalf of Mr. Lupo and Mr. Young, Your Honor, waive the formal reading of the both gentlemen stand mute. They've been advised of their rights.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. These are possession of controlled substance offenses, positions as to bond.
No objection to a 5,000 personal bond on both.
Thank you.
No objection, Your Honor. No objection.
Thank you. Bond will be set at $5,000 personal in each file. For both of you, you are not to purchase or possess any illegal substances. That includes prescription drugs for which you do not personally have a prescription. Next court date, December 3rd for probable cause conference, December 9th for preliminary examination, both in front of Judge Jefferson. Thank you.
Thank you.
Let me know when they're ready on Binkley, Reagan.
I'm ready, Judge.
Thank you. EDC, do you guys have Ross and Jennings? You guys interview Ross and Jennings?
Yes, ma'am.
Thank
Well,
you.
Ross never showed up, Your Honor. Ross was a Zoom that never showed, I don't think.
We bringing Jenkins now.
Thank you. 30 seconds to close the breakout. There's the Ross file, no appearance. Okay, I'll get you to unmute, please, for Mr. Binkley. Mr. Binkley, I need you to state your name, please.
Anthony Richard Binkley.
Thank you, Mr. Binkley. You got some traffic tickets, traffic misdemeanors where you missed your court dates. When you missed your court dates, judges assigned to those cases issued warrants. They set bonds. I'll set the warrants aside today and give you personal bonds on your tickets. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the ticket. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and/or a $500 fine. Ticket number U684-47624 alleges August 26th of 2024 in the area of Adams and Clifford, possession of drug paraphernalia. Then U688-31424 alleging July 15th of 2024 at an address on Woodward, possession of drug paraphernalia. On both of these, you have a pretrial date, December 20th at 9 a.m. in front of Judge Yancey. Now calling case number 240-606-6101, people of the state of Michigan versus Anthony Binkley. Counsel.
Lisa
Right
Coyle
with you, Mr.
appearing-
Jennings.
Lisa Coyle appearing on behalf of the people.
Praying on behalf of Mr. Binkley, Your Honor, waive the reading stamp. Notice been advised of his.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Charge here has to do with breaking and entering a vehicle with damage. Positions as to bond, please.
Your Honor, the people have no objection to a personal bond. I do see he's in the hospital at this point, but I'm asking for a tether and for the following reasons. He does have a long history of theft offenses, as well as he has a pending entering without owner's permission in 36th District Court. He had a failure to appear on that on September 18th of this year. He has a 2010% bond set on that by Judge Bryant. He also has a pending case in Third Circuit, a larceny over 200 with subsequent notice enhancing it to a felony. He has a failure to appear on that on September 30th of 24. He failed to appear at the arraignment on the information before the Honorable Deborah Thomas. I do note that there on Odyssey, it showed the bond, it appeared to be remand with a $10,000 bond with a tether. So in this matter, Your Honor, I believe a tether would be appropriate. Mr. Binkley and told the police he wanted to get arrested. He didn't want to be in the street again. But so it's not really a question. He is not he's more of a hindrance to the community because he's stealing and breaking into other people's cars. But at this point, he does not show up for court. So I'm asking for that tether.
All right, thank you, Mr. Reagan.
Judge, I understand the people's concern. This is a non-assaulter case. I'm asking for personal bond. I do understand there have been some capious history. There's some prior criminal history. My client understands, Judge, come to court. He does have some medical situations that are very serious, but I am asking for the personal bond, Judge.
Thank you. Bond will be set at $20,000 personal, finding Mr. Binkley not to be a danger to the community. However, the court does find him to be a flight risk in terms of reappearance for court. So I am ordering a GPS tether with no restrictions before release. That tether is simply to track his whereabouts and make sure that we know where to go find him for court. All right, next court date. December 2nd for probable cause conference, December 9th for preliminary examination, both in front of Judge Jefferson. Thank you.
Thank you.
All right. Thank you, Mr. Binkley. Have a good day. All right, Mr. Jennings, come back. Mr. Jennings, come back. Thank you. All right, calling case number 240-606-6401, people of the state of Michigan versus Bernard Jennings. Is that you, sir? State your name.
Bernard Austin Jennings.
Thank you. Council appearances, please.
For the record, on behalf of Mr. Jennings, waive the reading, stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Looks like this was like a prior eviction, and then he went back, and then there's allegations of flight from the police. Am I thinking about the right case? Yes. Okay. All right. Positions as to bond, please.
Your Honor, Mr. Jennings, the people have some concern about Mr. Jennings returning to the location here. He does not have any very recent criminal history. He does have a pending ordinance violation case, and looks like Taylor, where he is currently on a personal bond. He was arraigned on that, looks like October 28th. So just a few days before this, he was arraigned on that and given a personal bond. So we do have some concerns that about him then being found in this location. Your Honor, I did look at the eviction paperwork, and it looked like the eviction order had been entered some weeks before, Your Honor, but this is non-assaultive. We're going to ask for a higher personal bond with a no contact with this location. Mr. Jennings does not appear to be accused of being the person who, at least at this point, who caused the fire damage of the property. It's alleged that he was squatting. So I'm not going to ask for a money bond, but I'm asking for no contact at this point.
Thank you.
No objection to personal bond, Judge.
All right, thank you. Finding no danger to the community or flight risk, bond will be set at $10,000 personal. Mr. Jennings, you are not to return to the address on Portland Street as a condition of your bond, all right? If you go back there and you're found there, you're gonna end up back in here. You understand?
I do not.
Okay, well then I can keep you there if you don't understand that you can't return to Portland. So either you're gonna give me your assurance.
To be with my mother.
You may not return to the address on Portland. Do you understand that?
Okay. Can I leave this place, please? I do not like being in this facility. I do not like being behind bars.
I don't blame you. You may leave as long as you're not going to return to Portland. Hey, be quiet. If you assure me that you're not going to return to Portland, yes, you may leave that place.
Okay.
Do I have your assurance? Thank you. 10,000 personal, do not return to the address on Portland. December 4th for probable cause conference, December 10th for preliminary examination, both in front of Judge Giles. Thank you. All right, everybody have a good night.